Thank you.
You're welcome.
Mr. President, could I inquire the senator from the 1st?
Senator from Johnson, Senator from the 1st, do you yield to the Senator from Jefferson? I had just seen him. I know he was in the chamber. Do you yield to the Senator from Jefferson?
I do.
Proceed.
Your rent's due.
Say that again?
Your rent is due.
I know. I feel badly. I realize that.
And I'm also going to have to charge you for digging your car out of the snow.
Well, I'm not sure you're the one who did. Well, you helped.
I helped.
Well, now the question is, do I get a rent abatement for the fact that there was absolutely no snow removal whatsoever from the parking lot in the first place? I mean, as your tenant, aren't I entitled to snow removal?
Yeah, I usually just wait for warmer temperature.
Well, that's one approach. We finally got it this weekend in Jeff City. There's not the snow drifts.
You're right, though, when you spoke about this the other day. At 4 o'clock in the morning, I pull onto Bolivar Street, and I see your hazard lights on.
Yeah.
And that was the last thing that any of us wanted to have to deal with at that time.
That's right. I did what I could to extend what was already a very enjoyable morning for everybody.
You know, I think it's interesting to point out that 3 times in the last 2 years, we've laid labor bills over because of inclement weather.
You know, if we wait long enough, you never know. We might get another storm through on this one.
Well, my point is that Jesus was a carpenter. And I think there might be a correlation to that. But
now, he wasn't a carpenter for a public employee union, was he?
I don't remember. I wasn't there.
Me either. I just take it all in faith.
Right. I had an understanding that you'd like to make some inquiries.
You know, I would. I want to, you know, we've obviously got the amendment from the senator from the 10th on the floor currently. And I can't remember. Do we have a roll call on that? Do you recall if we do or not? We're not sure.
Believe so.
Well,
we could ask the president of the Senate. I'm going to
seems to be shaking his head. I would assume that.
I'm going to end my inquire of you for a second.
Very good.
Mr. President.
Senator from Jefferson.
Can I inquire of you?
State your inquiry.
Do you know if there has been a roll call requested on this amendment?
There's no indication up here that there's been a roll call.
Mr. President, could I inquire the senator from the 1st?
Senator from the 1st, you yield.
I do.
Proceed.
Senator, from my understanding, there's no roll call request.
You know, I was of the same understanding.
So,
see, there's that.
But then inquiries of me, or
well, no, I was what I was wanting to do was first of all address that. Obviously, we're on the current amendment, but I wanted to work through because I have not been. I know that you have spent some time in an effort to see if there is a version of this bill that would allow us, if not to agree, at least agree to disagree. And it's my understanding.
And I thought we were close Thursday. And I apologize. I had not visited with you Thursday or over the weekend to discuss.
Well, I'm a deadbeat tenant. I don't blame you. That said, what I want to do, because I've not been at the table on this, is go through the bill and sort of figure out what the real fault lines are here if I can. I don't know if that'll be a terribly meaningful or helpful inquiry, but I'd like to do that with the sponsor just because I've not been a part of those conversations, and I want to know you know, what, if any, flexibility there is. If there are no amendments that are going to get taken, there are no amendments that are going to get taken, but I at least want to talk through the whys and wherefores of what all's in this bill.
Well, then I have a conference call in 9 minutes that probably is only going to take me about 10 to 15 minutes. So I was needing to cede the floor over to somebody else for just a short time. So.
Sure. Well, I appreciate it. I will do my best not to inquire of you 10 minutes from now.
Thank you. Thank you, Mr. President.
Senator from the 1st.
While the senator from the 22nd is still in the room, I would ask that we have a roll call vote on this amendment, if I could get 4 members standing.
Seeing 4 members standing, you will have a roll call.
Mr. President, may I inquire of the senator from Phelps?
Senator from Phelps, do you yield to the senator from First? Proceed.
I do.
Good evening, Senator. How are you?
I'm fine.
Very good. So we have an amendment on the floor right now that would simply strike the first 4 lines of the bill. Is that right?
That's my understanding, yes.
And that section of the bill states that no sum shall be withheld from the earnings of any public employee for the purposes of paying any portion of dues, agency shop fees, or any other fees paid by public employee members of a public labor organization or public employees who are not members. So the section that is contemplated by this amendment specifically pertains to, among other things, dues. Is that right?
That is my understanding, and you know, and I think you're referring to the Senate Committee Substitute, Senate Bill 29, and you know, the bill deals with paycheck protections, what has been dubbed, and so that's exactly what we're trying to do in the legislation. In other words, it does not restrict freedom of workers to join a union. It doesn't restrict them from supporting them through their dues, and it lets them donate to their favorite causes. They just have a little more active role in how it's done.
So if I'm a public employee and I work for the state or presumably some political subdivision thereof in a bargaining unit that is unionized, I can, under lines 1 through 4, can I object to dues being taken out of my earnings? Is that basically what that first section says?
The first section says that you can't automatically deduct it in this original legislation. In other words, it cannot be deducted. You have to make those contributions separate from your paycheck.
Well, what if I don't? What if I'm a member of a bargaining unit? Maybe even a member of the unit. What if I just don't want to pay my dues?
Then you would not be a member of the union. Now, if you get benefits, that there are non-union paying members, and they have those fees deducted.
Well, what if I'm a member of the bargaining unit? I'm not a member of the union. Okay, all right. So if I'm a member of the union and we have this change in the law, and I don't want to pay my dues, can I stop paying my dues, leave the union, and keep my job?
According to this legislation, yes, and I think that is a law in Missouri now.
Well, I'm not sure I understand that answer. If that's the law in Missouri now, why do we need lines 1 through 4 in the bill?
You know, and we've heard the argument that I think supports passage of this legislation that, you know, we're doing all this stuff, so why are we doing this now? It's all required. And I don't think that's exactly right. But I don't think that you can be required to join a public union to keep your job in Missouri.
So it was the to keep your job part of my question that you were saying is current law now. So, well, I mean, do you anticipate that the effect of lines 1 through 4 might be that you'd have some public employees who would discontinue paying dues simply because they now can?
Possibly, but I think it makes a more informed membership. In other words, if they are working and involved with the organization, then I think they're going to be more likely to pay their dues. I don't think they're just going to let it slide. If they're not very active, then yeah, maybe, but I think most that are very actively involved are probably going to make sure those dues are paid. Just like you pay your insurance or you pay anything else.
But under this section, you don't have to, do you?
You do not have to. Well, if you're going to be a member, you have to pay it. You have to write the check yourself.
Well, and what I want to make sure I understand in terms of current law on that. I mean, if I'm a public employee under current law, dues can be withheld from my check, right?
If you're not a public employee,
If I am a public employee.
dues can be withheld. They are withheld now. Yes, that's
Right.
true.
So you're contemplating, rather than having it be a paycheck deduction like FICA or federal income tax withholding or state income tax withholding, you're contemplating that union members would need to, what, write a check and pay it like a bill?
Yeah, opt in, so to speak.
Well,
The way it is now, they have to opt out. And there's been discussions on how smooth that is.
what have the discussions been on how smooth it is to opt out?
Well, some of them feel that they don't have that option, that it's not as easy to go and ask for that deduction to be discontinued as someone like to believe.
Well, are you imbued of the notion that there have been hordes of public employees who have been asking to have the opportunity to write a check to pay their dues rather than having it deducted from their paycheck?
I have had those conversations, yes.
Really? Because I have to tell you, most of the labor folks that I've heard from think it's pretty important that in the interests of the continued smooth operation of their union, and mind you, we're not talking about political contributions here. We're talking about dues which go to the operation of the union, collective bargaining, and other benefits. Most of the folks that I've heard from think it's pretty important in the interests of solidarity and just the efficient operation of the union that they have the ability to deduct dues from the paycheck. So if you don't mind my asking, who have you heard that from?
Different organizations and different groups, members of them from back home that I wouldn't want to name.
I'm sorry, you said from back home that
That I wouldn't want to name.
Okay. Well, that's your prerogative. I understand. I just understand that for me it's a little hard. It's a little hard for me to. It's a little hard for me to understand where folks are coming from if I don't know who we're talking about. So Section 1, the first 4 lines of the bill, which is what this amendment raises, seems to me to be the one portion of the bill that deals with plain old regular ordinary dues as opposed to political contributions. Is there another section of the bill where we're talking specifically about dues other than this one?
I think that's the main part about dues. The rest of the bill pretty much deals with where political donations are made and giving the employee the option annually to sign where they would like those deductions to go.
Well, let's work through some other sections of the bill, but I'll tell you, I think there's a reason the minority caucus leader advocated perhaps moving past the MoDOT and snow removal crew amendment and getting this amendment on the floor, and that's because I think it goes to the heart of the matter and one of the biggest conflicts. Because I got to tell you, it's one thing to be talking about political contributions. It's another thing to be talking about the dues that union members pay that go into the smooth and efficient operation of the union, that go to benefits administration, collective bargaining, all sorts of things that those dues go for, that have absolutely nothing to do with the political process. And I think that there's an important.
I think that's definitely true in private unions. I don't know that it's so true in public unions. We've had that discussion as well, and we haven't really gotten an answer as to whether or not. How are some of those monies moved and from state to state, or where does some of the money come from? And I think public unions may be a little bit different than private, but I do not absolutely have that answer.
Well, I was going to say I'm not sure I understand why that would be the case. When you say you think that public unions might be different from private unions with respect to operating dues versus political expenditures, what do you mean?
Well, I don't think it's been totally answered. That question that you just asked is if as to whether they are absolutely separate, like they are in private unions. I don't know that anyone is actually auditing those books.
Well, do you have any reason to believe that there's a lack of separation?
Possibly.
Possibly. Well, what makes you say that? I mean, are we talking about speculation here, or are we talking about empirical fact?
We're talking about we don't know. We haven't got that question answered for us to any degree of certainty.
Well, regardless of separation of function within a union, you would agree with me that money that is used for political contributions is money that gets donated out to, in most cases, candidate committees, sometimes other kinds of political committees. And when we talk about political contributions, isn't that what we're talking about?
I think the political contributions go that way, and I don't know that we know 100% about the dues and the agency fees.
Well, how does your bill address that then?
The first 4 lines.
So, well, that's helpful. So, let me ask you this then: if I mean, we can agree that political contributions are one thing. So, your concern is that dues are going to political purposes. Is that your concern?
No, my concern is that we protect the paycheck of the employees. In other words, I want them to have the control of where the money goes. In other words, whether or not the money is removed. And I think it not being automatically deducted makes them be a little more informed as to where money's actually going from their paycheck deductions.
Well, you'd agree that there's other ways to inform them besides getting rid of paycheck withholding, right? I mean, we have a Human Resources Department here in the Missouri Senate. Most of us have paycheck withholding of some kind here, and there are all sorts of HR things that go on in this building that there are other ways of finding out about other than whether I have a particular deduction made from my check. Wouldn't you agree?
I think that's true. So, I think this definitely makes it makes the employee be informed.
And you say that employees gain knowledge through not having a line item deducting sums from their paycheck.
Well, I think it gives them more rights. In other words, this is employees' rights and paycheck protection. Their dollars are short like everyone else's.
Well, would you agree with me that if I'm a member of the union, that I have an obligation to pay my dues?
If you are taking part in some of the advantages that the union is bringing forward, then yes, you should pay dues, whether you're a member of that union or not.
Well, even if I'm not taking advantage of the union's benefits, don't I still have an obligation to pay dues? I mean, like any other association, right? If you're a member, you're paying dues.
Well, that's your choice, and that's what we're trying to do with this legislation. Make it a choice, an informed decision, as I mentioned when we first started talking about this.
So, are you saying you think that people should have the ability to free ride?
No, I don't think that. I think that's another discussion that we don't have with this bill. This bill's pretty narrowly focused on what it does, and it's pretty simple, straightforward. And as I said, it really doesn't prevent anyone from doing exactly what's happening now, but it does give them more options, I think.
Doesn't prevent anybody from doing what they're not. Well, okay. Well, I mean, you're specifically giving them the option not to pay their dues, right? I mean, all they have to do is nothing, and they don't pay their dues, right?
If they choose to do that, I think they would. If they're a member and active, they're going to pay their dues. It's just like, it's been brought up, Chamber of Commerce. Well, you have a choice there, whether or not you're a member and whether or not you pay your dues. You don't have to do it just because you're a businessman in an area. And so we want to give people the same option here. It's not automatically deducted There are other service organizations that are pretty much the same way.
But we're talking about an organization that is inextricably intertwined with their employment, right? I mean, they are represented at the bargaining table in terms of their compensation and benefits by the organization whose dues they are obligated to pay.
Well, you have to remember in Missouri, public employees are not allowed to collective bargain and strike. So, what are their union dues actually getting for them?
Say that again. I'm sorry. I'm not sure I have the same understanding of the law that you have.
Public employees in the state of Missouri are not allowed to collective bargain, except in certain areas.
And those exceptions in your mind are what?
I think St. Louis County teachers are one.
Well, was there not an executive order issued under the Holden administration? I realize the Blunt administration might have made a different executive order, but what's your understanding of the status of those executive orders regarding public employee collective bargaining? And I'll tell you, I certainly have a similar understanding with respect to the right to strike, but we're talking about collective bargaining.
Right. Well, I guess it depends on your definition of a collective bargaining or the right to strike. They don't have the right to strike or collective bargain, as strike being the main issue that they use. I think Governor Holden's executive order allowed state, municipal, county employees to unionize. That was his executive order. Governor Blunt executive order basically did Senate Bill 29, and I think it was struck down by one of the appellate courts, or at least really limited.
And then
is that your understanding?
Well, then in the education context, we have the independent school decision, right?
Right.
And that basically says that teachers have the right to bargain collectively through representatives of their own choosing, which, if memory serves, is language that comes from our state constitution.
Well, I think most school districts do not collective bargain that way, except St. Louis School District does have that ability, and I think there is a bill that's been filed to try to correct that. But as far as teachers in the state of Missouri walking a picket line or whatever, I don't think they're viewed as an essential service, so to speak.
Well, let's be very clear. When you say walk the picket line, you're talking about a strike. You understand that the right to collectively bargain and the right to strike are separate concepts.
I do.
And I will tell you, I served on a school board in St. Louis County, not the city of St. Louis, but in St. Louis County for 9 years, from 2001 to 2010, and I actually happened to be board president when, actually, I think independence may have been handed down right before I became board president. But I will tell you that our district policy prior to independence was to hold what we called meet and confer, which was a process whereby there would be, it happened to be a 4-building district, so we had one teacher from each of the 4 buildings as the teacher delegation, and then there were 2 board members and 2 administrators. That was the board administration delegation, and we had the meet and confer process whereby the sides would exchange lists of proposals pertaining to compensation, benefits, and working conditions, and without either side being bound really to stay at the table, we would work through the different proposals in an attempt to arrive at a contract that was agreeable to all. Not that the board ceded at the time its legal authority to move forward in the absence of agreement by the teachers, but that's what we called meet and confer. In fact, I was one of the board delegates to that process in 2005, if I remember right. So when independence came down, it was an issue that was squarely addressed in our district. Our board policy said you get 4 teachers to the table, and it was the view of some on the board and in the administration that independence did not impact that particular board policy, even though Now those rights morphed into collective bargaining as the Missouri Supreme Court interpreted the state constitution in the independence decision. But the teachers had a different view. They frankly pointed directly to the state constitution and said, no, the board and the board policy do not get to choose who our representatives are, which is to say one teacher from every building. We, the teachers, under the Missouri Constitution and the independence decision, have the right to choose. I mean, the words in the Constitution are representatives of their own choosing. And I was the board president at the time and successfully persuaded my board that I thought that they were correct, and I thought that if the board went to the mat over that issue, that we were probably going to get sued and we were probably going to lose. And the board elected to revise the policy to make it clear that the teachers could bargain through representatives of their own choosing, basically mimicking the language in the state constitution. And as a result, now you have an additional representative that's been added to the process on the teacher side, and an additional representative was added to the board administration team through that process. That's the solution we arrived at in Afton. But all of that is to say we very much have collective bargaining in our K-12 institutions throughout the state, and it is a new area of the law. Independence has been a few years ago now, but it's a relatively recent development, and districts are still sort of wading through all the implications of it. There have probably been a couple of instances where some vagueness in terms of the implications of independence have led to lawsuits. I'm not aware of any that have made it as high as the Missouri Supreme Court. But, you know, the legislature, of course, had an opportunity to legislate in this arena, and none of those bills have ever gone anywhere. There's been, it seems like there was one group that was advocating the notion of binding arbitration. There was another group that felt that there should be proportional representation in districts that had multiple agencies or multiple unions or organizations representing district employees, that all of them should have a seat at the table proportionate to their membership, and that was another approach that was taken. And I don't recall any of those bills ever making it very far. Certainly none of them ever made it into law, and so as a result, what you've had in this area is vagueness. you have what the state constitution says, you have what the independence decision has, and not a lot else to go on. But that's the state of the law in that area. So when you say that you don't think we have public employee collective bargaining in Missouri, I'm just not sure that we're altogether on the same page on that issue. But regardless of that, there's another provision in this bill that I want to ask you about, and we've talked about the first 4 lines, and I want to go toward the end of I want to now ask you about the last 3 lines, and I know there's been some discussion of this. The last 3 lines of the bill say that the bill shall not apply to first responders, and it cross-references a definition of any labor organization that represents such an individual. Again, why is that language in the bill?
I think that first responders are kind of viewed as a necessity for the community.
And teachers are not?
Well, as far as police, fire, I don't know what rises to what level. I know that the first responders are strictly that, first responders. They're the ones that we probably need for protection of the community on an immediate basis. Not saying that teachers aren't necessary. I have a lot of teachers in my family. But and this language, this carve-out, has stood the test of the courts, and most any other carve-out has not. So I think that's why that this is in the language.
I have to say I'm not sure I understand. What is it about being a first responder that differentiates you from other public employees in terms of having the automatic withdrawal of dues from your paycheck make a difference that is so important that we put it in law?
Well, if your home's burning, if your business is burning, if you're being robbed, I think it's pretty much been viewed by the courts that these folks are pretty necessary in that protective service that they offer. I mean, that's in my mind, and that's what I've read that seems to be where the courts kind of come down on allowing that carve out.
And again, how does Paycheck impact that?
What do you mean, how does Paycheck?
Well, I mean, what difference? I mean,
apparently they've asked to be carved out, and due to the service that they offer, it'd be kind of like, you really don't want your brain surgeon going on strike if you have a brain tumor.
has there been any political fallout or ill will expressed about the fact that you've got one particular type of public employee that's getting exempted here and when none of the rest are?
It has been, and I do not have that. Recently there was a decision, and I don't know that it went all the way to the Supreme Court, that said that that carve-out was legal. I will try to find more information on that for you.
I appreciate that. I appreciate that. Yeah, I just don't understand. Well, I guess my question is, so you seem pretty dug in on the notion that there ought to be this one carve out, but no others.
Yes.
And I'll tell you, I mean, we've seen there have been, gosh, what would you say, a dozen amendments circulated to this point, proposing to carve out one different type of employee versus another. We've already had the snow removal crew and transportation worker road crew amendment. I know I've seen at least one for teachers, and there might be two or three different ones. I thought I saw one attempting to add to that exemption. Let's see here. Now I'm shuffling papers on my desk. That's always a dangerous thing to do mid-sentence here. But I thought I saw, there's road crews. Let's see here. Department of Public Safety. I mean, I recognize they may not be technically first responders, but gosh, how do you differentiate? I mean, if the importance of first responders is their contribution to public safety, why wouldn't the Department of Public Safety also be somebody you would want to exempt from this?
Well, I think that the Department of Public Safety has such a large group of people that are involved in public safety, different organizations, that it would be difficult. And I agree with you. They do a lot of, and at times probably first responding. But I think mostly we kind of look at public safety itself as something that you may do long term, not in the short term, as a first responder would do.
Well, and forgive me, but I mean, it seems to me the Department of Public Safety is one agency, right?
It is one agency with a lot of different groups under it, yeah.
Well, and you'd agree with me, we've got a whole lot of different police departments in our state, right?
Right.
A whole lot of different fire protection districts in our state. I mean, it seems to me if the concern is the number of different organizations, or for that matter, the numerosity of the employees, it seems to me, and I suppose I could stand corrected on this, but I've got to think that we've got more firefighters and police officers serving the public in the various departments scattered throughout the state than we have employees of the Missouri Department of Public Safety, wouldn't you think?
Well, there may be, but I don't know that I want to go tell them that they're not first responders, and therefore we're gonna put them in the legislation. So
are you saying that you think that if you're trying to avoid classifying the Department of Public Safety as first responders or not first responders, I mean, is it your view that they're possibly already encapsulated within the carve-out that you've got in the bill?
There's some groups in there, maybe. I think highway patrols under the Department of Public Safety, I think they're viewed as first responders.
Well,
the fire marshal is probably not a first responder. He's there after the fact.
well,
Does that make any sense?
respectfully, I'm afraid I'm not sure I'm following. I mean, if so, you're saying it's your view that there are probably some first responders in the Missouri Department of Public Safety, but not everybody who works in that department is a first responder?
I'd say that's right, yes.
Well, and let's get to implementation challenges. And again, I don't get me wrong. I'm glad that police officers and firefighters are exempted currently from the bill. And as you might imagine, I'd prefer to exempt all public employees from the bill because I oppose the bill. But the implications of what you just said. If I've got an ambulance district, I mean, would you agree with me as a paramedic, a first responder?
Yeah, I think if you will look on line 62 of page 3. It defines under subdivision 3 of section 192.800 that represents these individuals that we've carved out. And I apologize, I usually have that book down here and I do not.
Well, and I will say, if there's somebody that happens to have handy a copy of 192.800, that would be 192.800, that would be very helpful to me if there's anybody who might be able to track that down. But just to get a sense of what those folks are. But I just, within an ambulance district, let's just say for the sake of argument that 192.800 says public employee means people like paramedics, but not people like, I don't know, the clerk at the desk at the same ambulance district office, or, for that matter, somebody in the police department who answers the phones as opposed to patrols. I mean, don't you potentially have similarly situated employees within the same agency who would be implicated differently by this carve-out?
I think that we will listen to the definition rather than speculate at this point.
And I appreciate
Senator
that.
from the 13th is looking at it now, I think.
And that's helpful. That's helpful. I'm just, I'm not sure I understand the rationale. I mean, another one of these amendments that might be coming talks about employees of the Department of Mental Health, and I realize that they may not be first responders either intuitively or under 192.800, but you'll agree with me. I mean, I've been told that the most dangerous job in state government are some of the folks working at the state, at the Fulton State Hospital. That you have folks who work with a population that can at times be dangerous, and you do have state employees who put themselves in harm's way in that facility from time to time. Would you agree with that?
They have a very dangerous job. I don't know that you would call them first responders. We'll see what the definition says.
Very good. Very good. Well, I'm confident somebody will bring that up here for me at some point, possibly. But even if we assume, for the sake of this discussion, that they're not first responders under 192.800, I mean, wouldn't you agree that these people have a dangerous job that puts them at risk of physical injury, perhaps even to a greater degree of frequency than some folks who might meet the definition of first responders, yet they are not going to have their union dues automatically deducted from their check under your bill?
I don't know that I want to make that decision for them or for those that are what we consider first responders in the state. I think maybe that they should, the carve-out seems to be one that stands the court battle, and at this point I want to stick with it.
And I respect that. I respect that. Let's look at, I now have a copy of 192.800 sub 3, and it defines first responder as follows: any person trained and authorized by law or rule to render emergency medical assistance or treatment. Medical assistance or treatment. Such persons may include, but shall not be limited to, emergency first responders, which seems, forgive me, somewhat tautological. We define first responder to include first responders. Emergency first responders, police officers, sheriffs, deputy sheriffs, firefighters, ambulance attendants and attendant drivers, emergency medical technicians, mobile emergency medical technicians, emergency medical technician paramedics, registered nurses or physicians. That's the definition of first responder in statute. I don't know that we have any nurses or physicians who are state employees who are currently represented by a union. Are you aware of any?
You know, I don't know. I know that we do have quite a few employed by the state. Whether or not they actually have a union represent them, I do not know that. You know, it sounds like what we're defining is medical emergency. And, you know, you realize that most fire departments now also respond to all emergency calls. They are trained either as a EMT or they have a paramedic that is a firefighter as well as a paramedic. So they are trained in medical emergencies. So I think the definition is very narrow, and that's kind of what's in state law now. And I feel better about the carve-out, honestly, and I've read it a couple of times, but it does make more sense when you realize that it pretty much boils it down to medical emergencies.
Well, and just so we're clear, I mean, so a firefighter at the fire department would be exempted, but the janitor at the fire department would not.
That's probably right.
You know, we have, you know, we're here in Jefferson City, in Cole County, the senator from Cole, obviously. We have got a lot of state workers here in Cole County and in the surrounding areas, wouldn't you agree?
Yes.
A lot of those folks are public employees. Most of them, I mean, we're talking state employees here, so,
right.
I mean, your bill is going to have a significantly greater impact right here where we're standing in Cole County than it will in most other parts of the state, won't it?
I don't know that I would necessarily say that. I think there are probably a lot of municipal employees and county employees. Probably more of those folks are members of labor unions than are just state workers.
You know what? I think that's a fair point. I will grant you that. And I would suspect that there are other areas of the state where you might have possibly greater numbers. I'm not sure about greater concentration, but you'd agree with me that we have a pretty heavy concentration of state employees here in Cole County?
Absolutely.
Well, why? I mean, why do we want? I mean, why would we want to? I mean, and we're talking about men and women who, among other things, help this building to operate, and the many departments that we in state government have. I mean, why would we want to inhibit their ability to support their collective bargaining rights?
Well, I maintain this doesn't inhibit. It gives them the choice. There's nothing in this legislation that's going to inhibit their ability to collective bargain or do whatever they want to do. You know, I think it's pretty clear that you know, it does not restrict their freedom, and it gives them a little more opportunity to participate, I guess. But I would disagree with you that this restricts them.
Well, it makes it harder for them to pay their dues, right? I mean, right now, with the paycheck withdrawal, you can pay your dues by active omission, right? You don't have to do anything. You sign up, I suppose, at the front end, and the auto deduction occurs there, you know, from that point forward with no further action on the part of the employee. On the other hand, if this bill becomes law, if I want to pay my union dues, I've got to write a check, maybe every month, maybe every year, I don't know. But you go from dues collection through omission to dues collection through act, and instead of having a centralized process that is administered by maybe one payroll person at the union, you shift that responsibility to substantially every member of the union, right?
Well, yeah, that's probably true, but then you have to realize there are people that don't think that the state or the city or the county should be involved in collecting and banking these funds before they're sent in. So there's both sides of the issue.
Well, let's be very clear on that point, because I appreciate what you just said. Your concern is in part the notion that public entities, governmental entities, are collecting union dues.
Well, they're banking them, and I didn't, that's just part of the discussion. When you're discussing paycheck protection, I don't think you can avoid that part of the discussion.
Well, when you say banking them,
do what?
I mean, when you say banking them, they are collecting them and then transferring them to the union, right?
Right.
I mean, you agree with me if that transfer doesn't occur, which is to say if they actually bank it, would hold on to the money, collect interest on it, invest it, use it. I mean, if they do anything with that money other than transmit it, they're basically acting as a third-party administrator, right? I mean, they collect it and then transfer it on. If they don't transfer it on, that's in all likelihood in breach of their agreement with the entity that they've made the contract with, right? I mean, they have an obligation to transfer those funds to the union.
Yes, the state does, absolutely, or the county, or the city, the municipality.
And you find that objectionable?
Well, I say that is part of the discussion that you have when you talk about paycheck protection. Is there are quite a number of people that don't feel that's appropriate.
And you're one of them.
Well, I don't see why we should be in that business. I mean, it doesn't make a lot of sense to me.
Well, I mean, couldn't you, though, just as easily, I mean, there would be, you could carve around that, right? I mean, you could find a workaround such that if your concern is that at some point money which is ultimately bound to a union in the form of dues that is deducted from paycheck, I mean, you could have, for instance, you could have a public entity agree to transfer funds to a third party, a non-public entity, rather than directly to the union, right? And you could have that. You could have the straw man or straw woman, if you will, handling it, an escrow, if you will. You could do that. I mean, you would still find that objectionable.
Well, in this day and age, with computerization and online banking, I don't see why it has to be deducted from the check here. Why not have the same thing deducted from your bank account? There's nothing in this bill that would prevent that, and you're accomplishing the same goal.
Well, let's talk about that concept for a minute.
That's not in the bill. That's just something that I offered up that makes it easy for them to, if you want your dues deducted monthly, deduct it from your bank account. What's the difference? And then you don't have the state involved. You don't have a city involved. You don't have a county involved in separating this out and sending it on down the road, so to speak.
Is that a concept that has been part of the negotiations that were being alluded to earlier?
No, I think that's something you can do now. Why do you need legislation for that? We do it all the time, and paying our monthly bills.
Well, I appreciate you said. I must have gotten confused. You said a moment ago that you'd offered that up, but you sort of implying that it's something that had been pitched in part of these discussions. But I guess I misunderstood you.
No, I mean it's just something that's out there. And I guess that's counter to saying, well, you can't deduct it out of the paycheck, so they're not going to be a member. Why can't they deduct it from their bank account automatically if that's what they choose to do? And that's a personal decision. They have control over that procedure.
All right, let's talk about the second provision of your bill. We've talked about the first one and we've talked about the last one, but on lines 5 through 12, it says, no public labor organization shall use or obtain any portion of dues, agency shop fees, or any other fees paid by public employee members of the labor organization or public employees who are not members to make contributions or expenditures as defined in section 130.011, except upon the written authorization of such member or non-member received within the previous 12 months on a form described by subsection 3 of the section, signed by such member or non-member and an officer of the union. We're talking about political contributions here, right?
Absolutely. Mm-hmm.
So I want to make sure I understand your view of how that particular provision is going to work should this become law. I think we can agree. Correct me if I'm wrong, is it not the law already that you can't use dues for political contributions?
That is my understanding. This gives you an opportunity as an employee to direct where you want your PAC money or the fee that you have deducted for political contributions. You get an opportunity to say where you want to spend that, with what committee. Maybe you don't agree with what everyone else has decided that they should do as a group.
So, about an authorization, I think we might have more than 2 senators on the floor here in just a minute. I say that to alert the chair. I know we've been talking for quite a while now, but I'm going to ask you some more questions here about sub 2.
Senator from the 14th, what reason do you rise?
Mr. President, I seek unanimous consent to introduce some special guests.
Seeing no opposition, proceed.
Thank you. Mr. President, to my right and your left, I have members of my district who are state representatives. We're having a special event in my office this evening. We're having a beer and a wine tasting. So please, if you would welcome Representatives Bill Otto, Margot McNeil, Mary Nichols, Susan Pace, Sharon Pace, Rochelle Walton-Gray, Reverend Tommy Pearson, and Courtney Curtis. It would be wonderful for everyone to recognize them.
Body will welcome the guests from the 14th. Senator from the 1st, proceed.
Mr. President, I was, of course, inquiring of the senator from Phelps regarding sub 2 here. So just so I understand, if I'm a public employee and member of a union, and any portion of, we say dues, agency shop fees, or other fees. Is it your view that there's any other money that I pay that goes to the union?
I think that union members are allowed to make contributions to PAC or political PAC.
Voluntary political contributions?
Well, and as I said earlier, I don't know that we absolutely know about public unions as opposed to private unions and the audit process.
Well, I just want to say that, and I understand where I think you're going with that, but there are committees that I've seen or PACs that I've seen that have the word voluntary in them, implying that it's something, and I may be just demonstrating my own ignorance here, not being a member of a union, but sort of implying that the union member funds that go into that particular voluntary PAC are something apart from what they have to pay in to be dues members in good standing. Do you have is that consistent with your understanding, or is it your view that that's not necessarily what we're talking about?
Well, I think that's I think there's some discussion, but I think for the most part that's how it's split up, and then you decide what you want to contribute to a PAC And the way it's done now, I think that's automatically taken out as well. This would give you an opportunity to sign in or opt in to contributing and allow you to say where you want the money to go, the name of the committee that you want it to go to. I would say that majority are going to go to the committees that the union representation have, agreed upon. But there may be members that have family members or other folks that they don't want their money going to support the opponent. And this gives them that right.
So if you have a local, let's just say, that has 100 members who are public employees, and there's 100 of them, and each of them has a different candidate running in a 100-way state house primary. And each of them says on their sub 3 form, I want my share of this to go to that candidate. What winds up happening is that one union ends up giving to all 100 candidates in a 100-way demolition derby because 100 different people have 100 different views of it.
Well, if that's their view and that's their opinion, then I think that it should be honored, yes.
Okay. So, but that's how obviously it's a somewhat attenuated scenario, but in theory, there's nothing to stop that scenario from unfolding.
No.
Isn't that sort of antithetical to the notion of the collective?
Well, we're kind of speculating on something that, I think the reality is that we give folks more control over where their PAC money's spent and whether or not they want to contribute.
Well, is the idea behind that just to stop contributions to unions altogether? Because, let's face it, isn't it kind of 6 1/2 dozen of the other? My making a voluntary contribution to the union, which I then dictate where it goes, versus my simply just cutting a check myself to the committee that I want to support?
Right, I think you could do both if you wanted to, as long as it's your control.
Let's talk about, I'm sorry.
It is your money. It's your money. That's the whole point. It's your money, and you should be able to direct where it goes. Now, if you can sell your idea to enough people, then you're going to get a lot of people behind your idea, and probably the entire voting bloc, but you may not be able to swing them.
So your concern is, and I'll tell you, this happens from time to time. In fact, I think this debate started a couple of Mondays ago amidst a snowstorm with the senator from the 7th and the senator from the 22nd talking about my race. And I had a set of circumstances where I happened to have a primary with a fellow Democrat whose spouse had been the business agent for a very prominent and very well-respected local union in our community. And I had a general against my predecessor in this seat, who also, who won the AFL-CIO endorsement in the race. And they had suggested that there might have been members of different locals that might have had different views about those endorsements, and I'm certainly not here to relitigate all that. I spent plenty of time on that last year. Thank you very much. But my point is, in the real world, the way this works out currently, you have situations where, apart from my own, put that to one side for the moment, but you have situations where you might have a union make an endorsement or a contribution that not every member of the local who paid in and whose financial support allowed that contribution might agree with, right? You can have a situation where the union makes a donation that a member disagrees with, right?
That's what they do now, yes.
And that's your concern. You think that should never happen, that the collective should always be subordinated to the will of the individual.
Well, I think that you should have control of where the money goes, and if they're consistently not supporting candidates you support, then you should have the opportunity to sign off on whom you would like or what committee you would like.
We're all taxpayers, right?
We're all taxpayers, yes.
And we don't agree on how every tax dollar that we spend gets spent, right?
That's right. That is collected by either the state or the federal, and we don't get much input a lot of times on how that money's spent. But in this situation, this is more on the individual level. I think you should have a little more.
Well, I'll tell you, I'm a member of Generation X. I have never known a time when the national debt wasn't like, at least, I think $3 trillion is the smallest number I really remember. And I really hate all this deficit spending we've been seeing in Washington ever since I hit first grade, basically, in 1980. And yet, you know, it's not as if I get to say when we're coming up on April 15th, it's not as if I get to send a note to Washington saying, I think that my tax dollars should be spent on this, this, and this, but not that, and oh, don't deficit spend. You know, we're mortgaging our children and grandchildren's future. I don't get to do that, right?
Yes, and that is federal or state tax that you're talking about. Not a political contribution through your labor union.
And I realize there's a distinction, but I'm just trying to get. The point that I'm trying to illustrate is that sometimes in life we do things collectively that individuals might disagree with.
But this is one time we don't have to.
Well,
if you vote for this legislation, that will fix the problem.
Well, and I don't really see that as a problem necessarily, and I say that as somebody who, you know, as a member of a collective, the United States of America, I disagree with some things my federal government spends money on, but you know, it is what it is. I just, you know, I wouldn't change that though. I'm very proud of our country, and you know, I recognize that you know, we don't always do things in a way that any of us agree with, but that's what we're all here for. And I just don't. I mean, I just don't see why we. I just don't see why a person who wants to be represented by a union, is a member of a union, dues paying, should not be able to do that without having to write a separate check, whether it's for their dues or for politics. I'm very concerned that this undermines the effectiveness of unions, and I think that that's not good for not only working people. I don't think that it's good for any of us really. I think that we do better when people in bargaining units or similarly situated employees within a given group have the ability to come together to negotiate their compensation and benefits, whether they're public employees or not. And I realize you and I might have a different view of that.
Yes, obviously.
So would you, I mean, I know that the senator from the 22nd was talking about this earlier. I mean, would you prefer that we be a right-to-work state?
My personal opinion, yes.
And I appreciate your being that candid about it, and obviously I have a different view, but you know, we'll have to agree to disagree on that. What I want to take a little bit more time to do is to continue to go through this bill, not having discussed it with you before, not having discussed it on the floor to this point, again, to see whether, you know, I recognize you and I are going to probably disagree on this bill at the end of the day. I want to see if there's a way we can get to a place where we can agree to disagree, and if we can't, so be it. But that's what I want to do. So the next section of the bill is sub 3. It's on page 1 and 2, lines 13 through 29. It says that the authorization referred to in subsection 2, which we were just discussing of this section, shall be made on the following form, the sole purpose of which is the documentation of such authorization. And The form's title shall read in at least 24-point bold type, consent for political use of dues fees, and shall state in at least 14-point bold type the following specific text. Quote, signing this form authorizes your union to use the amount of $, and it has a blank, from each of your dues or agency shop fee payments during the next 12 months as a political contribution or expenditure. And then another box. Signing this form requests your union to use the amount of $ blank from each of your dues or agency shop fee payments during the next 12 months as a political contribution to the, and then it says name of the committee. Check applicable box. You are obligated to sign this authorization, you are not obligated to sign this authorization. Your signature below is completely voluntary and cannot in any way affect your employment. So my first question, I apologize, I don't mean to be flippant here, but we talk about 24 and 14-point bold type. Is there a reason you decided bold as opposed to italics or underline or double underscore?
No, that's just, I think it specifically points out that type so it is easier for folks to read. Gives an example. Consent for political use of dues, fees, that kind of thing. But no.
So why legislate the form?
I think it makes it clearer and people understand what they're signing and what they're signing off on.
And you have some concern that wouldn't be the case in the absence of putting it in statute?
This was suggested language by one of the drafters we were working with.
Okay. So, just so I understand, you've got two different boxes that somebody could check. What's the difference between the two boxes?
One of the boxes says how much money you want to give, gives the amount, and the other one, the committee that you wanted to go to.
All right. So I guess I'm confused. In sub 2, I think you told me it was your interpretation that what that means is that the employee or union member, or the employee union member, dictates who gets the contribution. As I look at 3, it looks like there's maybe 2 options instead. The second option would have them dictating what committee gets the contribution. The first option seems like it might delegate that to the union itself. Am I misreading that first section in the form on paragraph 3?
Well, it tells the union how much you're going to have deducted from your or sent in from your paycheck or whatever, what you're going to do with it.
Got it. So the first box says you're authorized to use X amount as political contribution or expenditure. So that it's your interpretation that does not delegate to the union the discretion to decide how it's actually spent.
Right. It does not, because we're asking for you to name the committee. And it may be the same committee,
I have to tell you.
It may be a continuing committee.
And I disagree with this bill. I disagree with this form, but I will tell you, and maybe I shouldn't. I think the way this is set out, it really is confusing from the standpoint that it's not clear to me what happens if somebody checks one box and not the other. It would seem to me to be a lot more efficient to say, basically to roll it all into one form where you say, you can take this money, or, you can use this amount for an expenditure, and here's a committee I want it to go to. I guess my question to you is, what if somebody turns in this form, they've checked the first box but not the second? What do you do with that?
Well, I think the second box they have to pretty much fill out the committee that they want the money to go to.
What if they don't know? What if they're like, well, I support what the union wants to do. I'm supportive of having my dues or agency shop fee payments going to politics, but I don't know much about politics. I want to trust the pros in my view on it. I'm not that involved, and I think there are people around here who might know better than me. So I'm not sure what committee I want to send this to. Can I just delegate that, or are you taking that right away from them?
Nope. They can write down the committee, the PAC that the union is in support of.
I see. Well, when you say that, all right, so when you say that, are you talking about a campaign committee, a candidate committee, or are you talking about like a union voluntary PAC?
A union voluntary, any committee they want.
Got it. So you're saying if I'm a public employee union member and I want my dues to support a candidate, but I'm not sure which one, I can just check both boxes and write in the name of a voluntary PAC that's that the union recommends, or what have you, or that it runs. I don't know the exact legalities of that, so I don't want to mischaracterize it, but I can do that.
Yes.
That's a helpful clarification. I appreciate it. But I could also say candidate X, right?
It could be.
Okay. All right. So that's the form, and I appreciate it. I understand it a little bit better with the explanation you just provided.
Well, you have to realize this is legislation that we passed through the Senate, and this thing's been pretty well vetted over and over, so to speak, and it's kind of the language that we have landed on that seems to work, that seems to be able to make it through the finish line in the Senate.
Well, and I appreciate that, and note that this is my first year in the body. There was a paycheck bill that made it to a House vote, I think, in 2011, I think. Don't hold it against me if there was one that reached a floor vote in 12 as well. I don't remember one, but let's just say the debates in the House can go a whole lot swifter at times, and I don't think the paycheck bill that we debated in 2011, if I recall, it might have been on the floor for, well, I'll say it this way, I'm pretty confident that it was on the floor in the House the entire time, less time than we've already spent tonight, to say nothing of the other times that this bill's been to the floor. So my exposure to this subject matter, at least in the legislative arena, is considerably less extensive, and so I'm not as familiar with the intricacies of this bill in various renditions that we've had over the years, and I appreciate your taking the time to bring me up to speed on it. The next section of the bill, sub 4, page 2, says that any public labor organization that uses any portion of dues, agency shop fees, or other fees to make contributions or expenditures under subsection 2 of this section shall maintain records that include a copy of each authorization obtained under subsection 3 of this section, the amounts and dates funds were actually transferred, the amounts and dates funds were transferred to a committee as defined in section 130.011, and the committee to which the funds were transferred, records maintained under this subsection shall not include the employee's home address or telephone number. So I guess my first question is why the last sentence there?
Well, I think this pretty much satisfies the Ethics Commission. That section of law deals with what the Ethics Commission does on reporting, contributions to political committees. So I think that's what that's designed at, and they probably don't need to know the name or the home address or the telephone number of the person contributing.
So we want to...
The records that are maintained, that's not necessary, I don't think. I mean, Ethics Commission, you're probably going to have to give a full disclosure, but I don't think that's public always.
All right, so we want these contributions. I mean, I note the form doesn't have a spot for the name of the contributor.
Well, I think this is all being done now. That's pretty much in law.
Let me back up to sub 3 in that long form, that short form actually. Are you contemplating that the union member's name is going to be on that form?
No, I don't think it will be. No.
So okay, let me understand that, because let's say again we have a local with 100 members, right? And
Well, I guess the name is going to be on it because they're signing the form to the union as to what they can do. So yeah, their name's going to be on the form. Where to direct?
but does the bill say that?
Yeah, it says on line 92, signing this form.
I'm sorry, line
22, I'm sorry.
22.
Right,
Signing this form, okay.
right. So it's going to be a name.
And then, so you contemplate a signature blank after line 29?
Right.
Okay, so, and are we going to, well, again, not to be cute, but if we're going to legislate the form and say the form has to say exactly this and nothing else, I just want to make sure that it's usable and that this law can be implemented in the way that you intend, if that's what the will of the legislature ends up being. I mean, I will tell you, my signature's pretty darn indecipherable, and so are we going to require or allow them to print their name too?
No, it's not on the form that they have. It's just signing off.
All right. So if you've got a local union with 100 members, 50 of whom want their dues to go to political contributions, 50 of whom do not. All 50 who want their dues to go to political contributions have signatures that look kind of like mine, which is to say, not like their name. How do you know whose money to apply where?
Well, I think that most of us can do a more legible signature, or if it is that terrible, then they print along with signing. I would think in this situation you'd want them to know where you're directing your contribution.
And I'm not asking all that to be cute. We're legislating a form, so I want to make sure that it's usable. Next question. I mean, so you're in your view, empowering members of the union to dictate where their dues go to. Why shouldn't police officers and firefighters and other first responders have that right too?
You know, in the carve-out and the discussions that we had a couple of years ago, and I'll have to apologize, I don't remember exactly why we went down this road, but it was, this was the agreement that we came to. I think it's a good, workable agreement. This thing has been, as I said, tested all the way up and seems to work. Most anything else doesn't. So that's why we've landed on this language.
Do you want just for the sake of this discussion, a janitor who is a state employee who is unionized, do you want that person to be able to say, I want to support candidate X, but you don't want a first responder, a firefighter, a police officer, a paramedic to be able to say, you know what, local union, any portion of my dues that goes to politics should support candidate Y. They shouldn't have that right, but the unionized state janitor would under this law, under this bill. Under this bill, what you've described is factual. I think that the carve-out, we're going to allow them to, and they may end up going down this road. You know, I don't know. They may, by vote of their locals, do this. I hope they do. But you don't believe the power of the legislature of Missouri should require it?
No.
You don't think that police officers and firefighters and paramedics and other first responders should have their unions be required to give them a say in where their political contributions go? Only other state employees should receive that benefit in your view of things?
First responders typically are left out because of the fact they are first responders. They typically don't go on strike without being able to cover their district well.
Why should a janitor have the right to say, I want my dues to go to candidate X, but a police officer who got shot at last night not have the same right?
Well, I'm not making that decision. That was a decision that apparently they made as a group, that they wanted to be carved out, and that's what we allowed to happen a couple years ago.
And let me say this, because my example might be misconstrued by others, I want to be very clear that, in my view, all of our state employees provide, and all of our public employees provide a very valuable contribution to what we do as a public, in the public. Some might have more dangerous jobs than others, but if my example struck anybody as attempting to elevate the valuable services that different people provide differently, I really didn't intend that. So I'm not meaning to pick on anybody. I just am trying to understand the philosophical consistency, if any, that runs through this bill, and why we treat some kinds of public employees differently than others about something that just has to do with, union dues collection and union political contributions. And I'm just not sure I understand why we have the differentiations that we do in the bill. So in sub 4, which we were talking about a minute ago, dues, agency shop fees, other fees, records have to be maintained. I think we can at least agree that that's reasonable, right? Right. They're probably required to do it under federal law now anyway.
I think it's right.
So in section 5, we ask, where we say that copies of all records maintained under subsection 4 of this section shall be sent to the Labor and Industrial Relations Commission established under statutory cross-reference. Why would we do that?
Well, someone needs to keep a copy of the records, and that seems to be a logical choice.
That's not required now, right?
Do what?
That's not required now, is it?
Well, I think...
if a labor union cuts a check to my candidate committee, are they required to send a record of that to the Labor and Industrial Relations Commission currently?
I don't know that they send it to Labor and Industrial Relations. They probably send it to the Ethics Commission, that report.
Obviously it's disclosed to the Ethics Commission. Although I'm not sure that, they would have to report it there, but right now it doesn't go to Labor and Industrial Relations that I'm aware of. But to your point, everything that we're talking about in sub 4 is going to get disclosed to the ethics anyway, right? Under chapter, 130?
Yes, and this just maintains the records.
So why have, all right. So, well, right now, the fact of the contribution is disclosed to ethics, but, the forms in sub 3 don't go to ethics. So now all these forms go to Labor and Industrial Relations, where presumably they can be sunshine, right?
Yes.
So anybody with standing to seek public records under the Sunshine Law could then discern the identity of every single public employee union member who feels that their dues should be used for politics, and which committee that they specifically wanted to go to, right?
Well, I think that's true now under the Ethics Commission, is it not?
Well, I'm not sure that that's the case. When local number 1,000 or whatever, to pick a number out of the air, when local 1,000 through its PAC contributes to a candidate committee, what MEC gets is a report from the PAC saying we gave money to candidate committee X, and a candidate committee that says I received money from the PAC for local 1,000. It doesn't say that, John Doe and Jane Smith said that this money could come through the PAC to this candidate committee. That's not currently, the identities of the donors into the PAC might be disclosed, but under this bill, if John Doe says, I want my money to go to candidate Jane Smith, that's sunshineable, even if it's under the de minimis exception, the $100 exception in the MEC. And all I want to point out here, I guess, is that you're requiring disclosure that isn't required under current law. And I've got to tell you, I'm sort of the view that we should have perfect transparency in our campaign finance, so I'm not necessarily as concerned about that. I just want to make sure that it's understood that this bill puts a lot of information in the hands of labor industrial relations that right now isn't there. And whether that's a good thing or a bad thing, I'm not here to say on that point. It seems like a lot of information going to a state agency that right now is not, especially when you already have MEC to begin with. Why have duplication? Why not just let the reporting to ethics stand and be enough?
We felt that this was important. You can offer an amendment to change it, and I've tried to answer your inquiry and your questions, and if you have more specific questions, I'll be willing to answer those. But if it's just a filibuster, then I want to end my part of the inquiry.
Well, I'm the one inquiring of you, and I see that you're sitting down. I'm not sure how that works. So, Mr. President, may I inquire the senator from the 10th?
Senator first. Senator from 10th, you yield inquiry. Senator first. Proceed.
Yeah, how does that work? I'm still kind of new here. I keep saying that every week.
Well, I think that the senator from Phelps has